Hello everyone. In this lecture, I am going to explain about right to equality, which is the first section of fundamental rights in the Indian Constitution. Fundamental rights are those rights which are essential for intellectual, moral, and spiritual development of citizens. As these rights are fundamental or essential for existence and all-round development of individuals, they are called fundamental rights. The fundamental rights are enlisted in Part 3 of the Constitution from Article 12 to 35. In this regard, the framers of the Constitution derived inspiration from the American Constitution. Part 3 of the Constitution is rightly described as the Magna Carta of India. Do you know what Magna Carta is? Magna Carta is the Charter of Rights issued by King John of England in 1215 AD. This is the first written document relating to the fundamental rights of citizens. It contained a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including America. The fundamental rights meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country. They protect the liberty and freedom of the people against the invasion by the state. In short, they aim at establishing a government of law and not of men. Fundamental rights are fundamental. It is in the sense that they are most essential for the all-round development of the individual. All-round development means material development, intellectual development, moral development, and spiritual development. Of course, fundamental rights are different from other rights available to us. While ordinary legal rights are protected and enforced by ordinary law, fundamental rights are protected and guaranteed by the Constitution of the country. Another difference is ordinary rights may be changed by the legislature by ordinary process of lawmaking, but a fundamental right can be changed only by amending the Constitution itself. So, the fundamental rights are so important because the Constitution itself ensures that they are not violated by the government. Originally, the Constitution provided for 7 fundamental rights. They are these. First one, right to equality. Second one, right to freedom. Third one, right against exploitation. Fourth one, right to freedom of religion. Then cultural and educational rights. Right to property. Lastly, right to constitutional remedies. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act of 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So, at present, there are only 6 fundamental rights except right to property. Now we are going to see about features of fundamental rights. First, we have to know that some of the fundamental rights are available only to the citizens. Those articles are Article 15, 16, Article 19, 29 and 30. Article 15 is prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 16 is equality of opportunity in matters of public employment. Article 19 is protection of 6 rights regarding freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, freedom of profession. So, these freedom are guaranteed to the Indian citizen only. Article 29 is protection of language, script and culture of minorities. Article 30 is right of minorities to establish and administer educational institutions. So, these rights are available to Indian citizens only. Other rights are available to all persons whether citizens, foreigners, or legal persons like corporations and companies. The next feature is fundamental rights are not absolute. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the court. Another important feature is they are justiciable in nature. That means we can move to the court if any of our rights is violated. Next important thing is the fundamental rights are defended and guaranteed by the Supreme Court. That means if our rights are violated, we can directly go to the Supreme Court. If our rights are violated, we can directly go to the Supreme Court, not necessarily by way of appeal against judgment of the High Court. Next feature is the Parliament can curtail or repeal the fundamental rights, but only by a Constitutional Amendment Act, not by an ordinary act. Another feature of the fundamental rights is they can be suspended during the operation of a national emergency except the rights guaranteed by Article 20 and 21. And one more thing, 6 rights guaranteed by Article 19 can be suspended only when emergency is declared. Then next one, Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. It expressively provides for the doctrine of judicial review. Article 13 makes all laws in force in the country immediately before the commencement of the Constitution void if they are inconsistent with the provisions of the Part 3, that is fundamental rights. This means that if there was a law in action before the commencement of the Constitution which in any ways did not conform to the fundamental rights, the law would stand void. Then the same article makes clear that in future the state shall not make any law which takes away the fundamental rights given by Part 3. This also means that Article 13 provides for the judicial review of all legislations in India, past as well as future. Article 13 imposes an obligation on the state to respect and implement the fundamental rights and at the same time confers a power on the courts, that means Supreme Court via Article 32, High Courts via Article 226 respectively, to declare a law or act void if it infringes a fundamental right. Then the law here does not only include the legislation but also an ordinance, order, bylaw, rule, regulation, notification. This means that Parliament as well as state legislatures cannot make any law which takes away the fundamental rights of the individuals. All laws whether made by a legislature and all executive acts must respect and conform to the fundamental rights. Then the ordinances promulgated by the President under Article 123 or by the Governor under Article 213 must also not be inconsistent with the implementation of the fundamental rights. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Kesavananda Bharati case in the year 1973 that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. So, Article 13 provides teeth to the fundamental rights and makes them justiciable, that is, enforceable in the courts. Now we move to discuss about right to equality elaborately. Under the section of right to equality, 5 provisions are there. Article 14 provides for equality before law and equal protection of laws. Article 15 provides for prohibition of discrimination on certain grounds. Article 16 states about equality of opportunity in public employment. Article 17 abolishes untouchability. Article 18 abolishes titles. We will see these provisions one by one. Now let us know about Article 14 in detail. Article 14 of the Indian Constitution clearly states that the state, that means the country, shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This law is applicable to all citizens and foreigners. To be more precise, the word person includes companies, statutory corporations, registered societies, or any other type of legal persons. It is important to know the above mentioned two words, equality before the law and equal protection of laws. The term equality before law is taken from the Constitution of England, which means equal treatment for all persons before the court. That is, the law will be blind, it will not see who is standing in the dock, rich or poor. There shall not be any privilege for any particular person. It means everyone will get the same punishment for the same crime. No person, be it rich or poor, white or black, minister or servant, shall be above the law. It means the law will be the same for both the minister and the servant. Then, equal protection of law. These provisions have been taken from the Constitution of America. The following provisions are given in it. The similar application of the same laws to all persons who are similarly situated. Equal treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws. All persons should be treated equally without any discrimination. The Supreme Court believes that the rule of law written under Article 14 is the fundamental element of the Constitution. Therefore, it cannot be abolished in any way, even by amending the Constitution. It is not like that the rule of equality applies thoroughly. There are some exceptions to this. That is why it does not apply in case of these circumstances and individuals. No criminal proceeding shall be initiated or continued against the President or the Governor in any court during his or her term of office. No court can issue an arrest warrant of the President or Governor during his or her term of office. No person liable to any proceeding in any court in respect of the publication in a newspaper or by radio or television of a substantially true report of Parliament or state legislature. No member of Parliament shall be liable to any proceeding in any court in respect of any statement or any vote given by him in the Parliament. No member of state legislature shall be liable to any proceeding in any court in respect of any statement or any vote given by him in the state legislature. Article 31C is an exception to Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. Article 31C was incorporated by the 25th Amendment to the Indian Constitution in 1971 with the intention to create a socialistic pattern of society, and it was the brainchild of Mrs. Indira Gandhi, the then Prime Minister of India. 31C, saving of laws giving effect to certain directive principles. Notwithstanding anything contained in Article 13, any attempt made by the state to implement any policies inconsistent with Part 4 should not be questioned in any court on the ground that it is inconsistent with the rights given by Article 14 to Article 19. But where such law is made by any state legislature, the provisions of this article shall not apply unless such law have been reserved for the consideration of the President of India and has received his assent. Then Article 15. Article 15 prohibits discrimination by the state against any citizen on grounds only of caste, religion, sex, race, and place of birth. Fundamental rights are provided to every citizen of the country without any discrimination. The word discrimination refers to make adverse distinctions with regard to or to distinguish unfavorable from others, while the term only means that discrimination can be done on the basis of other grounds. The second provision of the Article 15 says that no citizen shall be subjected to any disability, liability, restriction, or condition on grounds of any religion, caste, race, sex, place of birth with regard to access to shops, public restaurants, hotels, and places of public entertainment, the use of wells, tanks, roads, and places of public resorts maintained wholly or partly by state funds or dedicated to the use of the general public. Here it is worth mentioning that this provision prohibits discrimination by both state and private individuals, while the provision under Article 14 prohibits discrimination only by the state. Again, I repeat, here it is worth mentioning that this provision, that means Article 15, prohibits discrimination by both state and private individuals, while the provision under Article 14 prohibits discrimination only by the state. There are three exceptions to this general rule of non-discrimination. The state is permitted to make any special provisions to women and children. For example, reservation of seats for women in the local bodies and provision of free education to children. The state is free to make special arrangements for socially and economically backward peoples or for scheduled castes and scheduled tribes. Likewise, the state can make special provisions for the betterment of the socially and economically backward sections of the society or for the SCs and STs. Example, provisions regarding admission in the educational institutions in the private institutes, whether aided or unaided by the state. The last provision was added by the 93rd Amendment Act of 2005. In order to give effect to the provision, the Centre enacted the Central Educational Institutions Reservation in Admission Act in the year 2006, providing a quota of 27% of candidates belonging to the other backward classes in all central higher educational institutions, including the IITs and the IIMs. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed the central government to exclude the creamy layer among the OBCs while implementing the law. Now we are going to see about what is meant by creamy layer. Creamy layer is a term used to refer to some members of a backward class who are highly advanced socially as well as economically and educationally. They are not eligible for government-sponsored educational and professional benefit programs. The term was introduced by the Satyanathan Commission in 1971, which directed that the creamy layer should be excluded from the reservations of civil posts. It was also identified later by Justice Ramanathan Committee in 1993. The categories of people belong to creamy layer among OBCs are President, Vice President, Judges of Supreme Court and High Court, and members of Union Public Service Commission, State Public Service Commission, Chief Election Commissioner and Controller and Auditor General. Group A, B, Class 1, Class 2 officers of All India Services, Central Services and State Services. Employees equivalent post in public sector undertakings, banks, insurance organizations, universities. Rank of colonial in Army, Navy, Air Force and paramilitary forces. Professionals like doctors, lawyers, engineers, artists, authors, consultants. Persons in trade, business, industry and agriculture land above a certain limit. Now we are going to see about the income criteria in creamy layer. The creamy layer income criteria were defined as gross annual income of parents from all sources more than 1 lakh rupees defined by Satyanathan Committee in 1971. In 1993, when creamy layer ceiling introduced, it was 1 lakh. It was subsequently revised to rupees 2.5 lakhs per annum in the year 2004 and revised to 4.5 lakhs in the year 2008 and rupees 6 lakhs in 2013 and rupees 8 lakhs in 2017. The income criteria is usually reviewed every 3 years. At present, OBCs are entitled to 27% reservation in higher educational institutions and public sector employment if the gross annual income of one's household does not exceed rupees 8 lakhs. A person with annual income of 8 lakhs or more is classified as belonging to the creamy layer among OBCs and cannot avail of reservations. This is about the recent law that provides 10% reservation for economically backward sections is said to benefit poor upper caste as well as some farming communities. The 124th Constitutional Amendment received the President's assent on January 12, 2019. This amendment provides for 10% reservation for economically backward sections for the benefit of poor upper caste. This amendment amended two fundamental rights. Article 15, which prohibits discrimination on grounds of race, religion, caste, sex or place of birth. Then Article 16, which prohibits discrimination in employment in government office. This amendment provides for the advancement of the economically weaker sections of the society. It also makes a note of the Article 46, which asks the government to promote the educational and economic interests of the weaker sections of the society. Moreover, it provides reservation for people who have an annual income of less than rupees 8 lakhs or people who own less than 5 acres of farmland or people who have a house less than 1000 square feet in a town or 1000 square yard in a notified municipal area. Now we move to Article 16. Article 16 deals with the equality of opportunity in matters of public employment. Equality of opportunity means that all sections of the society enjoy equal opportunities. What does equal opportunity mean? The Constitution clarifies that the government can implement special schemes and measures for improving the conditions of certain sections of society, children, women, and the socially educationally backward classes. You may have heard about reservations in jobs and in admissions. You would have wondered why there are reservations if we follow the principle of equality. In fact, Article 16(4) of the Constitution explicitly clarifies that a policy like reservation will not be seen as a violation of right to equality. If you see the spirit of the Constitution, it is required for the fulfillment of the right to equality. The Constitution of India has given a wide interpretation of this article. Equal employment opportunity principles apply to access to jobs, conditions of employment, relationships in the workplace, the evaluation of performance, and the opportunity for training and career development. Article 16 is an instance of the application of the general rule with special reference to the opportunity of appointments under the state. It says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. The main objective of Article 16 is to create a constitutional right to equality of opportunity and employment in public offices. The article is confined to citizens as distinguished from other persons. Further, it is confined to an employment or appointment to an office under the state. But in the form of exceptions, the article also provides the autonomy to the state to make laws or special provisions for making residence as the criteria for employment or appointment within a state or union territory if sanctioned by parliamentary legislation under Clause 16(3). Reservation of appointments are posed for underrepresented backward class under Clause 16(4). Reservation in matters of promotion with consequential seniority to any class or classes of post for SCs and ST under Clause 16(4)(a). Filling up the backlog vacancies for SCs and STs irrespective of 50% ceiling imposed by the Constitution under Clause 16(4)(b). Prescription of profession of a particular religion or belonging to a particular denomination if the office is in connection with the affairs of any religious or denominational institution under Clause 16(5). Now, Article 17, Abolition of Untouchability. The practice of untouchability is one of the crudest form manifestations of inequality. This has been abolished under the right to equality. According to Article 17, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Parliament is authorized to make a law prescribing the punishment for violation of fundamental rights, and in exercise of this power, Parliament has enacted the Untouchability Act in the year 1955. It has been amended and renamed in 1976 as the Protection of Civil Rights Act 1955. This act was amended by the Untouchability Offences Amendment Act in 1987 in order to make the untouchability laws more stringent. It is also to be noted that a person convicted of the offence of untouchability is disqualified for election to the Parliament or state legislature. The Act declares certain practices as offences. Refusing admission to any person to public institutions such as hospital, dispensary, educational institution, then preventing any person from worshipping or offering prayers in any place of public worship, justifying untouchability on historical, philosophical or religious grounds or on the ground of tradition of the caste system, subjecting any person to any disability with regard to access to any shop, public restaurant, hotel or public entertainment, or with regard to the use of any reservoir, tap or other source of water, road, cremation ground or any other place where services are rendered to the public, then insulting a member of a scheduled caste on the ground of untouchability, or preaching untouchability directly or indirectly. These practices are punishable offences. But the normal provisions of the existing laws like the Protection of Civil Rights Act 1955 and the Indian Penal Code have been found inadequate to check offences against the scheduled caste and scheduled tribes. Recognizing the inadequacy of laws, To check the offences against the scheduled caste and scheduled tribes, the Parliament passed Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act in the year 1985 and Rules 1995. In a similar mode, the Parliament also passed the Prohibition of Employment as Manual Scavengers and the Rehabilitation Act in the year 2013. It seeks to enforce the fundamental right of manual scavengers against untouchability. The right to equality also provides that the state shall confer no title on a person except those who excel themselves in the military or academic field. Article 18 abolishes titles and makes 4 provisions in this regard. It prohibits the state from conferring any title except a military or academic distinction on anybody, whether a citizen or a foreigner. Then it prohibits a citizen of India from accepting any title from any foreign state. Then a foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. Then no citizen or foreigner holding any office of profit or trust under the state is to accept any present emolument without the consent of the president. So it is clear that the hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Diwan Bahadur, etc., which were conferred by colonial states, are banned by Article 18 as these are against the principle of equal status of all. I conclude by saying that the right to equality strives to make India a true democracy by ensuring a sense of equality of dignity and status among all its citizens. Thank you. If you find this lecture useful, press the like button, subscribe to my channel for notification of updates, share this video to whomever it may be useful.